This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about why a plaintiff will only get one bite at the apple, and that when you sue and lose, you can't sue the same defendants again for the same thing. In DAB 3 LLC et al. Versus Sandra Fitzpatrick, Alan Fischer, and Lawyers Title Corporation, a decision of the Court of Appeals of Connecticut on October 18, 2022. The plaintiff attempted to avoid the effect of the doctrine of res judicata by changing the names of the parties he's suing. After a suit to recover damages for fraudulent concealment, the trial court granted the defendant's motion for summary judgment in the first action, and the defendant Lawyers Title Insurance Company's motion for summary judgment in the second action, and rendered judgments from which the plaintiff Alan Fischer appealed. The Court of Appeal noted that Alan Fischer was appealing from and claimed that the court incorrectly determined that both of his complaints were barred by the doctrine of res judicata. The plaintiff was the sole owner, designee, managing partner, and assignee of DAB 3 LLC, and he was the sole person acting through and for DAB 3. In August of 2006, DAB 3 sued against 7 defendants. That was discussed as the 2006 action. In the 2006 action, DAB 3 alleged that the 2006 defendants were insurance brokers and/or agents. DAB 3 further alleged that it had contracted with the 2006 defendants to procure for DAB 3 a pollution legal liability policy with full and complete coverage for all environmental conditions with respect to a parcel of real property located at 60 High Meadow Road in Brookfield, Connecticut. Over the course of the next decade, the court issued a series of rulings fully resolving the 2006 action in favor of the 2006 defendants. Then in April of 2019, the plaintiff filed 2 lawsuits, of which involved the current appeal. The gravamen of the 2019 suits was that the defendants were liable for $2,049,185.62, a judgment rendered in the 2006 action because the defendants failed to procure adequate insurance coverage with respect to the property. The plaintiff alleged that prior to and throughout the 2006 action, the defendants intentionally misrepresented and fraudulently concealed which of the 2006 defendants was 1. The broker of the policy, 2. Fitzpatrick's employer, and 3. The party financially liable to the plaintiff. The plaintiff alleged that the defendants withheld the identity of the individual or entity that brokered the policy, so as to force DAB 3 to try the case and obtain a judgment in the 2006 action against a defendant purportedly without assets. Both of the complaints in the 2019 actions asserted 3 claims. 1. Fraudulent concealment pursuant to General Statute Section 52-595. 2. Common law fraud. And 3. Violation of the Connecticut Unfair Trade Practices Act, CUTPA. The defendants moved for summary judgment in the 2019 actions on at least 8 different grounds, including res judicata. The court granted both motions for summary judgment and overruled the plaintiff's objections. In the opinion of the Court of Appeal, the doctrine of res judicata provides that a valid, final judgment rendered on the merits by a court of competent jurisdiction is an absolute bar to a subsequent action between the same parties upon the same claim or demand. Res judicata prevents a litigant from reasserting a claim that has already been decided on the merits. Moreover, claim preclusion prevents the pursuit of any claims relating to the cause of action which were actually made or might have been made. Res judicata is based on the public policy that a party should not be able to relitigate a matter which it already has had an opportunity to litigate. In order for res judicata to apply, 4 elements must be met. 1. The judgment must have been rendered on the merits by a court of competent jurisdiction. 2. The parties to the prior and subsequent actions must be the same or in privity. 3. There must have been an adequate opportunity to litigate the matter fully. And 4. The same underlying claim must be at issue. The doctrine of res judicata prevents the plaintiff's attempt to relitigate claims on the basis of his purportedly new evidence. The Court of Appeal concluded that the same underlying claim was at issue in the 2006 action and the 2019 actions. The allegations are related in time because the 2006 action and the 2019 actions stem from the defendant's alleged procuring of insufficient insurance coverage. The 2006 action and the 2019 actions seek the same redress, specifically the more than $2 million in damages that the plaintiff allegedly sustained due to the defendant's failure to procure adequate insurance coverage for the property. The 2006 action and the 2019 actions arise from the same common nucleus of facts, particularly the actions and inactions taken by the defendants in connection with the alleged procurement of the policy. Both cases form a convenient trial unit that conforms to the parties' expectations. There would have been considerable overlap of witnesses and proof relevant to the 2006 action and the 2019 actions. The fact that the legal claims in the 2006 action, breach of contract and CUTPA, are distinct from the 2019 actions, fraudulent concealment, common law fraud, and CUTPA, does not preclude the application of res judicata. This case exemplified the policy considerations supporting the doctrine of res judicata, which is to promote judicial economy, minimizing repetitive litigation, preventing inconsistent judgments, and providing repose to parties as balanced against the competing interests of the plaintiff in the vindication of a just claim. The plaintiff's attempt to relitigate which of the defendants is liable for his lack of insurance coverage is merely a veiled attempt to collect his $2 million judgment from other parties against which he already has litigated his claim and lost. This is the precise type of action to which the preclusive effect of the doctrine of res judicata applies, and the judgments were therefore affirmed. In my opinion, the plaintiff was just a sore loser and found he was responsible for a judgment greater than $2 million that he believed should have been covered by insurance. He sued those who should have given him insurance and failed in the 2006 action, and then in 2019 sued again on the same set of facts. The law allows anyone aggrieved to sue for damages. However, when the aggrieved party litigates to judgment and loses, he cannot sue again. The old judgment stands and the new suit isn't new, and therefore it failed. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on zelma.com/blog, a blog that you should, if you do not already, subscribe to. You can also subscribe to my videos at rumble.com and on YouTube, and I'd appreciate it if you click on the like button and the Rumble button as you watch the video. And you might also be interested in subscribing to my Locals community and my Substack publications. Thank you for your attention.